Welcome back to Nova Real Estate Solutions. I'm Dwight Morris, a seniors real estate specialist here at Innovation Properties in Fairfax, Virginia. Today I'm addressing a critical concern for many seniors and their families right here in Northern Virginia: how to protect your home from potential Medicaid liens. As a seniors real estate specialist, I understand the importance of preserving your assets and ensuring your long-term security. This is a multifaceted topic, so I'm going to delve into the nuances and provide you with a more detailed understanding of the strategies involved. Medicaid is a lifeline for many individuals with limited income and resources, providing essential health care coverage, often including long-term care services, such as nursing home care. However, if Medicaid covers these substantial costs, the Commonwealth of Virginia may attempt to recover those expenses from the individual's estate after their passing. For most seniors, their home represents their most significant asset, making it a primary point of concern regarding potential Medicaid liens. Let's first clarify what a Medicaid lien entails. It's a legal claim filed by the state against your property to recoup the funds expended for your Medicaid benefits. It's important to note that this doesn't typically force a sale of your home during your lifetime, but it can significantly complicate selling or transferring the property later, and will likely need to be satisfied from the sale proceeds after your passing. One strategy that individuals sometimes consider to protect their home from potential Medicaid liens involves gifting the property to their children or other loved ones. However, this approach must be navigated with extreme caution due to Medicaid's look-back period. Here in Virginia, as in many other states, this period is typically 5 years. Any assets, including a home, that are gifted during this time can be subject to significant penalties, potentially leading to a substantial delay in Medicaid eligibility. The penalty is often calculated based on the value of the gifted asset and the prevailing average cost of long-term care in the Commonwealth. For instance, if someone gifts a $300,000 home just 3 years before needing Medicaid, it could result in a period of ineligibility lasting several months or even years, depending on the average cost of care in Virginia. Beyond the look-back period, gifting your home results in a complete loss of control. Once the transfer is made, you no longer legally own the property. This means you cannot unilaterally decide to sell it, borrow against its equity through a traditional or reverse mortgage, or even make significant alterations without the new owner's consent. Furthermore, if the recipients of the gift encounter financial difficulties, the property could be vulnerable to their creditors. For example, if your child faces a lawsuit and a judgment is entered against them, a lien could potentially be placed on the home you gifted them. Finally, gifting real estate can have significant tax implications for both the giver and the receiver. While the giver might not owe federal gift tax if the value falls within the annual exclusion or lifetime exemption, large gifts must still be reported to the IRS on Form 709. For the recipient, when they eventually sell the property, their capital gains tax will be calculated based on the original owner's purchase price, rather than the fair market value at the time of the gift, potentially leading to a larger tax burden. Given these complexities and potential pitfalls, gifting your home as a Medicaid planning strategy should only be considered after a thorough consultation with an experienced elder law attorney who can assess your specific situation and explore all other available options. A life estate allows you to transfer ownership of your home to someone else, known as the remainderman, typically your children, while retaining the legal right to live in the property for the rest of your life. You become the life tenant. When properly executed, the value of your life estate interest is generally not considered a countable asset for Medicaid eligibility here in Virginia. However, the value of the remainder interest that your children will receive might still be subject to the 5-year look-back period. As the life tenant, you typically remain responsible for ongoing property expenses such as property taxes and routine upkeep. The remainderman, your children, cannot sell the property outright during your lifetime without your consent. However, both the life tenant and the remainderman have distinct interests in the property, which could lead to complexities. For example, if the life tenant wants to sell, both parties would need to agree, and the proceeds would be divided based on actuarial life expectancy tables. Furthermore, the remainderman's potential financial or legal issues could still impact the property's title. Creating a valid life estate requires specific legal documentation, properly recorded with the Fairfax County Land Records or Prince William, to be effective for Medicaid planning. Transferring your home into a carefully structured, irrevocable trust can be a more robust tool for asset protection. Because the trust is irrevocable, you generally cannot directly access or control the assets once they are properly transferred. Here in Virginia, assets held in a properly drafted and executed irrevocable trust, particularly a Medicaid Asset Protection Trust, are often protected from Medicaid liens, especially if the trust was established and funded well outside the 5-year look-back period. The terms of the trust dictate how the assets are managed and eventually distributed to your beneficiaries. You would typically appoint a trustee, someone other than yourself, to manage the trust assets according to the trust agreement. It's crucial to understand that to achieve Medicaid protection, you generally cannot retain significant control over the trust assets. Irrevocable trusts are complex legal instruments and involve upfront and ongoing costs for their establishment and administration. Seeking expert legal counsel from an elder law attorney experienced in Virginia Medicaid planning is absolutely essential to ensure the trust is structured correctly to achieve your goals. Virginia does offer a homestead exemption, which can protect a certain amount of equity in your primary residence from certain types of creditors. However, it's important to understand that in Virginia, the homestead exemption offers very limited, if any, protection against Medicaid liens. Medicaid's right to recover funds from your estate is generally not subject to the homestead exemption. Therefore, while the homestead exemption can provide some protection against other debts, it is not a reliable strategy for shielding your home from a Medicaid lien in the Commonwealth. While not a direct strategy to protect your home's title, long-term care insurance can be a proactive way to pay for the significant costs of nursing home care or in-home care. By having a long-term care policy in place, you may be able to reduce or even eliminate the need to rely on Medicaid for these expenses, thereby avoiding potential Medicaid liens on your home altogether. Long-term care insurance policies vary significantly in terms of coverage, daily or monthly benefit amounts, benefit periods, and so-called elimination periods, which is the time you must pay out of pocket before the policy begins to pay. Premiums are typically based on your age and health at the time of purchase, so planning ahead and obtaining coverage earlier can often be more affordable. Exploring different policy options and understanding the specific terms and conditions is crucial. Some hybrid life insurance policies also offer long-term care riders, which can be another avenue to consider. Medicaid regulations in Virginia, as in other states, offer some important protections for the so-called community spouse. That's the spouse who is not applying for Medicaid. This includes the Community Spouse Resource Allowance, which allows the community spouse to retain a certain amount of the couple's countable assets, including potentially a portion of the home's value, to maintain their living standards. The specific Community Spouse Resource Allowance limit in Virginia changes annually, so it's important to get up-to-date information. Additionally, the Minimum Monthly Maintenance Needs Allowance ensures the community spouse has a minimum level of income. If the community spouse's own income falls below this threshold, a portion of the applicant spouse's income can be allocated to them. In situations where the standard community spouse resource allowance or minimum monthly maintenance needs allowance is insufficient to meet the community spouse's needs, it may be possible to petition for an increase. While spousal refusal exists in some states, it's a complex legal strategy with specific requirements and potential consequences that would require expert legal advice in the context of Virginia law. In certain documented hardship situations, the Commonwealth of Virginia may grant a waiver of estate recovery, which could prevent a Medicaid lien from being enforced against your home. Examples of hardship might include situations where recovering the assets would leave the surviving family members with insufficient means to live, or would result in the loss of a family farm or business that has been operational for a significant period. Applying for an estate recovery waiver typically involves a formal process with specific documentation requirements to demonstrate the hardship. As you can see, navigating the complexities of protecting your home from potential Medicaid liens here in Virginia involves understanding a variety of legal and financial tools, each with its own set of rules and potential consequences. Therefore, if you have concerns about safeguarding your home from Medicaid liens, especially as you plan for your long-term care needs in Northern Virginia, the most prudent step is to consult with an experienced elder law attorney or an estate planning attorney who specializes in Virginia Medicaid planning. They possess the in-depth knowledge of state-specific laws that can provide tailored advice based on your unique circumstances, family situation, and financial resources. They can help you evaluate the pros and cons of each strategy and ensure that any actions you take are legally sound and align with your overall estate planning goals. As a seniors real estate specialist serving Fairfax, Prince William, and Loudoun counties, I can certainly assist you with the real estate aspects of your long-term care plan. For instance, if selling your home becomes a part of your strategy, I can provide you with a comprehensive market analysis, guide you through the selling process with the sensitivity and expertise you deserve, and help you find suitable housing options if needed. My role is to help you with the real estate transaction itself, always keeping your best interests in mind. Thank you for spending this time with me today on Nova Real Estate Solutions. Protecting your assets, particularly your home, is a vital component of comprehensive long-term care planning. By gaining a better understanding of the potential impact of Medicaid liens and proactively exploring available strategies with qualified legal and financial professionals, you can take meaningful steps to safeguard your future and the well-being of your loved ones. Now, if you found this information helpful, please give this video a thumbs up and subscribe for more information on seniors real estate in Northern Virginia.